What would constitute a premises liability claim stemming from a sexual assault incident? Attorney Matthew Feller explains that. Imagine a parking structure in downtown Salt Lake City that has inadequate security and inadequate lighting. Due to the inadequate security and inadequate lighting, the parking structure welcomes criminals who know that the garage is dark and is empty of officers, cameras, and security guards. Now, imagine that the owner of the parking structure knows that a rape occurred in their parking garage and that the rapist was never caught. Rather than increasing security and purchasing cameras and adding additional lighting to the parking structure, the owner chooses to do nothing. Seeing that the parking structure is still dark and there are still no cameras and no security guards, the rapist returns 1 week later and rapes a second woman in the parking structure. In this scenario, premises liability law permits our community to hold the owners of the parking structure accountable for their negligent and conscious decision to do nothing. The parking structure provided the rapist the time, space, and opportunity to victimize multiple women. Now, premises liability law doesn't just apply to the inadequate security scenario. It applies to situations where unqualified and untrained staff members of a boarding school overact and break a child's arm or leg in an improper restraint scenario. It applies when a boarding school chooses to not run proper background checks and hires an employee that comes in and hurts a child, or when a boarding school hires an employee that they don't screen or call any references on, and this person comes in and ends up being a child molester. Call the personal injury attorneys at Feller and Wendt in Utah for a no-fee consultation. They will explain your rights and give you comfort in knowing they will be there every step of the way.